Case number 113117, Jesse Atkins v. Webcon et al.
May it please the court, Melinda Young on behalf of the appellant Jesse Atkins, and may I reserve 4 minutes for rebuttal, please?
4 minutes is granted.
Thank you. By way of summary, this is a Kansas workers' compensation case. In June 2009, Webcon, the employer in this case, was in the business of commercial roofing jobs. And Webcon was at the time based out of Hutchinson, but performed commercial roofing projects throughout Kansas and surrounding states, including Oklahoma. One evening, Jesse Atkins, the claimant in this case, was walking to a hotel that he was staying at for the week while performing work for Webcon in Oklahoma when Mr. Atkins was struck by a drunk driver.
Specifically, he was returning to the hotel from a bar.
Correct.
Where he had been engaged in recreational activities.
Correct.
And your task is to convince us that returning from a bar to the hotel was in the course of his employment.
That is correct. And that's really what the issue is in this case. In order to be compensable, the injury has to arise out of and in the course of employment. And generally, injuries do not arise out of and in the course of employment when the employee is on the way to start work or leaving work after completing the workday. However, when an employee has to travel to differing locations, travel is an integral or necessary part of the employment, and when travel is integral or necessary, the injury can still arise out of and in the course of employment even though the work day itself has ended.
Is there ever an end to the work day in Mr. Atkins' circumstance? Is it just 24 hours he's in the course of employment?
According to this court's decision in Kendall, the Kendall versus Fairco case and the Blair versus Shaw case, no, there is not an end to the employment.
So whatever happens, if he's wherever he or she is at under these circumstances, travel's required, costs are covered for the travel, then basically that entire 24-hour day that encompasses the work, you're covered by workers' comp because you're in the course of employment.
Yes, with one exception, and that being if a substantial deviation has occurred, if the employee has broken from the purpose of the trip or deviated from the activity contemplated by the employer in a way significant enough to constitute a substantial deviation.
What is the policy that supports your position in response to Justice Rosen's question? What's the legislature attempting to do with this principle?
Well, as the court described in the Blair decision, when an employee has to travel out of town and for the purpose of the work of the employer, the employee is subjecting themselves or is being subjected to risks that the employee wouldn't be subjected to in the normal course of the employee-employer relationship.
So if this had happened in the town where your client resided, he went to work in the same town, came home, then went to a hotel where there was a bar, he had a few drinks, was walking back to his house and got hit, that would be compensable as well?
I haven't analyzed that scenario for this case, but if Mr. Atkins lived in Hutchinson, the work he was performing was in Hutchinson, and he had completed the workday, had returned home, and then, as you said, went to a hotel bar that evening, I wouldn't imagine that would be covered or that would be a compensable injury.
It's after work hours, it's at home, no travel by the employer required.
Right. This situation is different in that Mr. Atkins had to stay out of town overnight.
He was in a different town,
He was.
but he wasn't working at that time.
Correct.
And I kind of wanted to back up. You said you hadn't analyzed my colleague's scenario, but don't we have to kind of look back at how this whole analysis started? And doesn't it all start with the going and coming rule?
It does.
That the further subset of cases that talk about travel integral to employment are a subset of going and coming rule cases, aren't they?
True.
How was this guy going or coming?
What the courts have said is that the statute says specifically that an injury does not arise out of and in the course of employment if the employee is coming or going.
Right.
But if travel is integral to the employment itself.
Right. So, the integral to the employment itself subset is only interesting from an analytical perspective if you've got someone who qualifies for going and coming to start with, right? Or does not qualify, if that's the question. So I'm asking, how do the facts here indicate that this person would be subject or not subject to the going and coming rule? Because this person is out of town, work ended at 7 p.m., it's 2:30 in the morning, he's made a decision, which is he's totally entitled to make, to leave the place of where he is billeted, if you will, overnight, and go enjoy some recreation, which he does, and this accident occurs when he's returning from that place on foot. He wasn't required to go anywhere on foot by his employer, was he?
He was not required to go anywhere on foot by his employer.
That's the start. And
But-
he certainly wasn't required to go recreate while out of town.
True.
But he was required to be in Enid, Oklahoma and stay in that specific hotel. And so that's your argument, is that he went on Monday and he didn't come back. He wasn't coming back until Friday.
Correct.
So
Correct.
all the time that he's not on the job site or even in transit to the job site and back to the hotel while he's out of town is still going and coming. That's your argument.
Yes.
Okay.
That is my argument.
From the time, sorry, so from
Or
the
not
time
going in.
from the time he leaves Hutchinson until he returns, if he's injured in any way, then he's entitled to compensation.
Yes.
How was the hazard increased by being in Enid as opposed to Hutchinson? Are Enid drivers especially prone to getting drunk and running people over at 2:30 in the morning?
Don't answer that.
Yeah, I was gonna say, I don't know if I have
want
the
I
answer.
can
good
answer
relations
that.
with us.
I would, well, first of all, starting with the Blair case, which specifically states that the entire trip should be taken as a whole and should not be, we shouldn't separate out just the trip from the hotel to the work site and the work site back to the hotel, that instead the entire trip should be taken as a whole. Here, Mr. Atkins, because he was staying in Enid and staying at a hotel that he was required to stay at by the employer and that the employer selected, that hotel doesn't have any kind of general common socializing area, and so it is common for the employees, and this wasn't the first time employees traveled from the Baymont Hotel where they were that was selected by their employer across the street to the Ramada. These guys are staying in a hotel overnight for the entire week and are walking across the street. They don't have their own personal vehicle, so they are leaving the hotel together, walking across the street to the Ramada, spending time in their restaurant bar, and then walking back over to the hotel to sleep at night. if this is similar to a situation where someone is sent by an employer to a conference out of town, and while the period of time that they're at a conference may have ended, they're still for on the trip and at the overnight out of town on behalf of the employer and in the service of the employer. And so a trip leaving the hotel to go to dinner and coming back would, under Blair, the entire trip would be taken as a whole.
You would agree that your argument only works if certain things happen. Number one, that it's employer-provided transportation to Enid rather than reimbursement for mileage. If he'd have taken his personal car to Enid, you couldn't make the same argument, correct?
I think that's correct.
And if they had reimbursed for a per diem for a hotel motel, and Mr. Atkins had selected his own place to stay, your argument wouldn't work, correct?
Yes, that's true.
So I guess when we're talking policy, it's a little hard to split those hairs and understand how it makes any difference from a policy standpoint. That the same scenario with driving your own vehicle or selecting your own hotel, you wouldn't be able to make this argument to us.
Well, part of the purpose behind the legislation and the decisions that have gotten us to this point is that when an employee is at the mercy, probably is too strong of language, but when the employee is in the service of the employer out of town for a trip, that the employee is, that the employer, both the employee and the employer are receiving a benefit as a result of that relationship and as a result of that travel and that trip. And so the policy being that the employee is, again, subject to risk that the employee wouldn't be if the employee had their own vehicle, was making their own decisions, absent from any of the circumstances created by the employer, where to go and when to go and how to get around. But when the employee is staying at the hotel selected by the employer, traveling with the employer, therefore doesn't have their own vehicle, they are subject to risks that other employees would not be in a normal, if you can call it that, employment relationship where they're in the same location. The Court of Appeals has, in what was particularly that stood out to me in this decision, is that the Court of Appeals has recently, in this case, in the Butera case and the Ostermeyer case, appeared to identify or acknowledge that, yes, we have the Kendall case and the Blair case, and acknowledged that, okay, when an employee travels out of town, travel is integral to the employment relationship. However, the Court of Appeals has then gone further and said when the employee stays at a hotel, the travel cuts off at the time the employee reaches the hotel, and so what has been called the exception to the going and coming rule is eliminated at that point once the employee is staying at a hotel. These recent decisions by the Court of Appeals directly conflict with this court's decisions in Kendall and Blair, which say the opposite and say that when travel is integral to the employment, the entire undertaking is considered as a whole, and only when there is a substantial deviation.
Considered indivisible.
Yeah.
The entire undertaking is considered indivisible.
Correct.
So no exceptions to arising out of and in the course of employment applies, which would typically apply in a normal workers' comp case when travel is entailed, as it is here. Is
Correct.
basically your position.
I'm having trouble pigeonholing this case under the KJRA because your issue statement is that the board overlooked substantial competent evidence, but the facts are not in dispute here. So it seems to me this is a question of law, which would put it under subsection 4, which would be the board misapplied the law. So which is it? I mean, with undisputed facts, this has to be just whether these facts fit under the statute for purposes of coverage, right?
Yeah, and I agree. In preparing for this argument today, I considered that and agree that it does appear that the Court of Appeals applied the facts incorrectly to the law versus.
It'd be the same thing as the agency. I mean, this is an agency review question, so we
Yeah.
have to look at the agency's decision.
Yes.
And the facts aren't in dispute. So the only question is whether those facts fit the workers' compensation coverage statutes, right?
Yes, and I've kind of gone back and forth in my mind on that particular question, but ultimately, yes, I think you are correct that the facts aren't in dispute. It really is an issue of whether the Court of Appeals applied those facts to the law correctly, applied the law correctly in this case.
It still gets back to whether the board applied.
Correct.
We're this KJRA, so
Yeah.
it's just whether the board applied the undisputed facts to the law.
Correct. Correct.
Any more questions? Thank you, counsel.
Thank you.
Good morning, Your Honors. Roy Hartman here today representing the appellee in this case, Webcon Incorporated. And at the time, the Kansas Building Industry Workers' Compensation Fund has now changed its name, is now known as the Kansas Builders Insurance Group. Basically, as you know, we're here today because the argument is that this claim is compensable as a workers' compensation claim because travel is alleged to be the intrinsic or integral part of this of Mr. Atkins' job. Therefore, the going and coming rule would not apply. That is the argument that's been put forth. Mr. Atkins is claiming that his visit to the bar at the Ramada that night must be considered indivisible as a part of his work trip to Enid, Oklahoma. And again, therefore, it would rise out in the course of his employment. The issue here, and what the board decided, the Workers' Compensation Board of Appeals, as well as the Court of Appeals, they rejected that argument that Mr. Atkins' work was, that travel was an intrinsic or integral part of his employment with Webcon.
They rejected the idea that this travel
That's
was
correct.
integral. I mean, this isn't a situation where he was injured in the course of riding or driving to Enid in a company vehicle or home from Enid in a company vehicle. Then this case would be easy.
That's correct.
What makes this difficult is this travel. Is
That is
this
correct.
travel integral?
And this travel involves a very long project in Enid, Oklahoma. I believe it's a grain elevator that was expected to last 3 to 6 months. And with the employer respondent being based in Hutchinson, Kansas, they solicited volunteers from their crew to go do this project. And the way they structured it was they would leave Hutchinson on Monday morning, take up a temporary residence in Enid, Oklahoma at a Baymont. They would work throughout the week. And Friday afternoon, around noon, they would knock off and head back to Hutchinson. Again, it's purely voluntarily. They did offer incentives to their employees, to make that trip. Mr. Atkins was one of those that did indeed make that trip. In rejecting this particular argument that travel was intrinsic to his employment, the board and the court looked at what Mr. Atkins actually did. He was a laborer in the respondent's commercial roofing division. He was not employed to drive. In fact, I don't even think he had a driver's license. His job was to provide labor on roofing projects, wherever they may be, and this one happened to be in Enid, Oklahoma. Driving was not, and travel was not more intrinsic to him than any other commuter on any other job. The services he performed, the labor he performed, were specifically to be performed at this grain elevator. And at the time of the accident, 2:30 in the morning, he was not earning a wage, he was not on the clock, he was not furthering his employers in any way, and he was not expected to perform anything for the employer at that time of day.
Counsel, can I just piggyback on that comment you just made and kind of back up analytically?
Sure.
My understanding of what's been called the going and coming rule is that it's effectively an statutory exclusion from the meaning of arising out of and in the course of employment.
I would agree.
And if that's the case, and it's merely a statutory exclusion, whether travel's intrinsic, whether this exclusion applies or not, if it does apply, it can end the case. But if it doesn't apply, that doesn't end the case, does it? Doesn't the administrative agency or the court still have to determine whether it was arising out of or in the course of employment?
I would agree. Your Honor, do you have a question? In rejecting these arguments, the board and the Court of Appeals looked at some other cases, some prior precedent that we talked about. One of them, and probably the foremost, Butera versus Fleur Daniel, if I'm saying that correct, Daniel Construction Corporation. In that case, the claimant, Mr. Butera, his employer required him to temporarily relocate for particular jobs, for construction jobs. In this situation, his permanent residence was 360 miles from where this job was, and this job was a long-term, 5-6 months like we had with Mr. Atkins. So what Mr. Butera did is he moved to a spot that was closer. He took up residence in a hotel, the same as Mr. Atkins. This particular hotel he stayed at was a mere 30 minutes from the job site. As in Mr. Atkins' claim, he was not responsible for payment of the particular facility. He was reimbursed. In our case, Mr. Atkins, the hotel was already paid for, so there wasn't a reimbursement issue. As in this case, Butera argued that this claim should be compensable, even though he's required to take up a remote residence. That court found that Butera was a fixed situs employee and that travel was not a part of his job as an iron worker or rigger, very similar to what we have with Mr. Atkins. He was a laborer in a roofing situation. Mr. Butera was not under his employer's supervision during his off hours, the same as with Mr. Atkins, nor was he expected to accomplish anything on behalf of his employers during those off hours. Again, the same as with Mr. Atkins. So at the time of his injury, Mr. Butera, he faced no greater risk than any other commuter who were traveling from their permanent residence. Again, the same as Mr. Atkins. Mr. Atkins, again, his job was was a laborer at that commercial elevator. His job started and ended in the morning when he got in the truck to go to the elevator, and when he returned in the evening to his temporary residence, it ended. He was not expected to do anything on behalf of his employers at 2:30 in the morning. The other case that the board looked at...
Counsel, what if the hotel had burned down?
I think we'd be in the same situation. I'd be here making the same argument today.
And what I'm driving at goes back to my earlier question, which is we're spending a lot of time arguing about whether or not this statutory exclusion applies. But if you could assume with me for just a minute and assume that it doesn't apply, I mean, what is just sort of the plain vanilla argument about whether or not this injury arose out of or in the course of employment?
I think what it really comes down to me, the bottom line, Your Honor, is what did the employer do that put Mr. Atkins at an increased risk or hazard? If my employer has me go out and do particular items that I would normally not do during the day.
And if you put somebody up in a hotel 300 miles from their home and don't permit them to have their personal vehicle, haven't you, arguably at least, you've tied their hands, so to speak, even in their off hours?
Your Honor, I would take exception to that because if you look back in the record, they were given the option. They were not required to drive in a company vehicle. They were given the option to take their own personal vehicle. They were also given the option of staying anywhere they wanted. But what worker in the right mind, when your employer is offering a free ride and a free night, would take that in lieu of having to pay for something themselves. So they weren't required to drive. They weren't required to stay at the Baymont. They could have stayed anywhere, but they would have had to pay for it themselves. So he made these decisions to do what he wanted to do. When he went to Enid, he didn't have to go. He didn't have to ride the company vehicle. He didn't have to stay in that particular place. He could have stayed at the Ramada if he wanted to, but he would have paid for it himself. So he took the benefit that his employers provided. The other thing is employers didn't mandate or require him to go out in the evenings. What's an employer to do?
Well, that gets to my hypothetical about the hotel burning down. I mean, do you now are willing to concede a distinction between those fact patterns, or is it just?
I don't, Your Honor. I'm sorry.
That's what.
I don't agree with that analysis.
Your analysis is a clock punching. That's the test. When you punch in, when you punch out.
And again, to me, there has to be some causal connection to the employment. And drinking in a bar at 2:30 in the morning and walking is not related to the employment in any way in the world I come from. And so we have the Butera case. We also have another case that was considered by the Court of Appeals, and it was Ostmeyer, if I'm saying that correctly. It presented a very similar situation and issues as well. Ostmeyer was a traveling nurse who would take these contractual employments that would span either 13 to 26 weeks. These were remote, not near home. Similar to Butera, Ostmeyer decided I'd rather shorten my distance, took up temporary residence at a hotel of her choosing, and while on this assignment, on a day off even, she was attacked and injured on her way back from dinner. And again, it occurred on a day off. The argument was put forward that travel was a necessary part of her job, is integral to that job, and it during her extended out-of-town trip and should be compensable. The Court of Appeals disagreed and found that the case was very similar and comparable to the Butera case, and found that it did not arise out in the course of her employment. And they found that at the time of the assault, she faced no greater risk than if she'd been at her home or any other hotel. And at the end of the opinion, uniquely, the Court of Appeals made the comment that to embrace Ostmeyer's position here would substantially broaden the employer's exposure on all claims. If Ostmeyer's injuries arose out in the course of employment, virtually any conceivable mishap during her hotel stay would be compensable, even a slip and fall in a hotel shower, food poisoning at a local restaurant. That court went on to say, we do not believe that such broad coverage is consistent with the legislative intent or with the appellate case law considering that question. That's where I line of thinking would come into that.
Counsel, do you agree this is a question of law? We have undisputed facts. This isn't a substantial competent evidence as to whether the record supports one particular factual finding versus another factual finding. This is a question of law, whether these facts are covered by the statute such that the injury can be compensable.
I believe it is a question of law, whether it's how the facts are applied and if they're applicable to that. It's interesting, the Court of Appeals in this case did spend some time on whether there was substantial competent evidence to support the board's decision. That is the standard they looked at in determining this, and in their opinion, as I'm sure you all read, they felt that there was substantial evidence to support that, and the board correctly applied the sound reasoning.
Right, but that's not what we're looking
Ostmeyer.
at here. That's my problem. I mean, I look at that Court of Appeals decision, and there's no reason to talk about whether substantial competent evidence supports the board's decision because these facts are undisputed. This is simply a coverage question.
Well, I believe that's how it was positioned when it was appealed, and that's what we briefed. I don't know that anybody in here, in our briefs, talked about a question of law.
Well, it seems to me it is a question of law, right?
Well, I think the facts are pretty straightforward. There may be some disputes here and there, but for the most part, the facts are uncontroverted.
I mean, we know that the employer we know that the employee was injured off the job site. We know the job site was remote. And we know that the employer provided temporary lodging. And with those facts, the first thing I think what Justice Stiegel is saying is the first thing we look at is whether the going and coming rule, as it's codified in 44-508, whether that applies, I don't think it does. If you just read the statute, it clearly doesn't. So now we're left with whether those facts fall under, the course of employment, right?
I guess I agree, Your Honor, yeah.
Okay.
I mean, that's the focus we look at.
I'm just trying to get focused on this thing.
I understand.
And to me, it's been difficult to get focused because of the discussion about substantial competent evidence when I don't really care when everything's undisputed.
I think the focus in this case is whether this claim arises out of in the course of employment. That is the question to be answered.
You agree the going and coming rule as provided in the statute does not exclude this claim?
I believe it does exclude this claim.
Okay.
Because you have to
I've got it in
find.
front of me. You explain to me how this language excludes that claim.
Well, the coming and going, you're talking about 44-508, which I don't have right in front of me. It provides, if I can find it here real quickly, I can.
Well, he wasn't on his way to assume the duties of employment,
That's correct.
and he wasn't, after leaving such duties, and the proximate cause wasn't, doesn't have anything to do with the employer's negligence. So I'm having trouble getting to the statutory exclusion, which means we're now off into the whole workers' comp statutory scheme, looking at whether this arises in the course of employment.
I guess I don't see, Your Honor, how, if we say the going and coming rule, if 44-508 does not apply, how does that make this claim compensable? Because it did not arise out of in the course of his employment. He was not on the job site.
That's a different part of the world, the statutory world. This statute says that arising out of and in the course of employment shall not be construed to include injuries, and then it goes forward. I'm just trying to say, how does that statutory language apply to this claim? And if it doesn't, then it's not excluded under this. It may not qualify, but it doesn't mean it's excluded under this statutory going and coming rule. That's all I'm getting at.
I'm just not sure how to respond to your argument, Your Honor. I apologize. The going and coming rule, I've litigated a number of claims over the years, and that usually involves situations where you're coming to your employer's place of employment. It might be the only route available, and you're injured before
That's
you
what the
clock in.
statute says.
Sure, those are the
This
cases
isn't
I've had.
that.
I agree. This is not even anywhere near to this guy traveling to and from his work. This is a claim involving him being out of town and being injured at 2:30 in the morning.
So you don't need an exclusion to prevail. In other words, if your argument as to the uncontroverted facts is adopted, you don't need the statutory exclusion, I think, is kind of the gist of these questions.
Yeah,
Would
again,
you
our
agree with
argument-
that or not?
Our argument goes back to the fact that it didn't rise out of in the course of his employment as the case law and statutes defined over the years. This is not a compensable claim.
Any further
See, I'm out of time, Your Honors.
Any further presentation?
No, Your Honor.
Any more questions? Thank you, counsel.
Thank you, Your Honors.
Thank you. I just wanted to address this.
Counsel, I'm sorry. I know you wanted to say something, but I'm just going to jump in
Sure.
and ask you about a separate statutory exclusion.
Okay.
There's the going and coming exclusion in 508F, but the second part of 508F also excludes any injuries to employees while engaged in recreational events under circumstances where the employee was under no duty to attend. Why doesn't that statutory exclusion apply in this case?
Well, I believe that it doesn't apply because that statute has at least been held to apply in situations where the recreational event or activity is something hosted or sponsored by the employer, as I recall, in a
The
situation.
company softball game.
Right, where the employer is hosting it.
So that would mean that the exclusion does not apply But what I'm asking is why doesn't it apply in this case? In other words, it appears to me that there at least could be an argument made that this injured worker was engaged in a recreational event under circumstances in which he was not required to be there by his employer. And the statute says that is excluded from the definition of arising out of and in the course of employment.
Well, again, this isn't a situation where the employee is, or the employer is offering a recreational event and the employee is attending. Where I think in hearing the court's comments about whether the going and coming rule really is applicable here, because we don't have a situation where the employee was on his way to the job site or on his way back from the job site. And that's really a great number of the cases that we have on this issue address that scenario. But what this situation does include is the question of, or the analysis of whether this is a risk, a workplace risk that is compensable because this employee was subject to increased risk as a result of the trip.
How do you stretch? I know you're relying on the employer requiring this worker to be in Enid, Oklahoma, without a car, without his own house. But how do you make that leap from requiring his presence in the community to the recreational endeavors that he engages in voluntarily while he's there? Back to kind of carry forward my colleague's question.
Sure.
We all agree that this wasn't a sponsored event.
Right.
But how would you say his requirement that he be in Enid, Oklahoma, translate into the exceptions to the exception?
Okay. I believe that the section addressing or excluding recreational activities sponsored by an employee is different because the legislature sought to exclude from the act injuries where an employer offers something of recreational nature that is not part of the employer's business, a company softball game that is offered, but the legislature saw that they didn't want to extend coverage under the act in that scenario. The scenario we have here is different in that in order to perform the work, Mr. Atkins and the entire crew had to travel and stay out of town over the course of a week, stay in a hotel, and the risks associated with that trip for the purpose of the work. I see those as two very different things than an enjoyable recreational activity offered by the employer versus a trip for to further the work of the employer and having to haul an entire crew. Again, there are a number of cases that have addressed more pointedly, I guess, the risks associated with work and the analysis in determining whether because of those risks the injury arises out of and in the course of employment beyond those that include travel to and from the employment.
Is there any exception or any injury that occurs that would have occurred to Mr. Atkins during his time that he was in Enid that wouldn't have been covered? I mean, basically, if this scenario, under the facts of this case, is covered, what isn't covered? Is there anything?
Well, there aren't, as I could find, I didn't find any, certainly Supreme Court decisions or Kansas Court of Appeals decisions that addressed that question specifically. However, there were several Workers' Compensation Board of Appeals decisions that did address when an employee is sent on a trip for a couple of weeks and put up in a hotel, same situation as here. And then the analysis became whether a substantial deviation had occurred. And there were some cases that involved, for example, an employee who was staying for 3 weeks in a different state at a hotel, and one of the weekends, a friend in a nearby town came and picked up the employee, and they went on a trip over the course of that weekend, and an injury happened while on that trip, away even from the city where the employee was working. And the Board of Appeals in that scenario said that was a substantial deviation. The employee had been picked up by a friend and left the town for the weekend. So applying that type of circumstance, if Mr. Atkins had someone who came who was not part of the crew, came and picked him up, and they traveled from Enid to Oklahoma City for the night, maybe that would be a substantial deviation. Something beyond what the crew was doing in their activities in Enid for the week that they were there, in the evenings after the work had ended. And there was another similar Board of Appeals decision that, now I'm not recalling the specific facts, but again, it did involve kind of leaving the area and doing something different than what the other employees were doing during the trip. So I could see that type of scenario. Otherwise, I think so long as the employee is staying in the hotel, doing what the employees are doing in the evenings, and the employer is deriving a benefit from that employee's overnight trip, and benefiting from not having to assemble a whole new crew of people in every single town, and the employee is therefore subjected to the risk of out-of-town travel. Those injuries that occur during that trip would be compensable under the Act.
To go back to a question that was raised some time ago, what is the policy that supports the examples you were just giving? Why should workers' compensation cover an employee who, yes, is out of town and decides to go drinking that night and gets injured? And it sounds like you're saying that would be covered if that is what most of the other employees there were doing. So if that is correct, what is the policy justification for coverage in that situation?
Well, I think generally the policy would be really because the employer derives a benefit from assembling a crew and sending them out of town and having them perform the work for them. The policy benefits the employee who is willing to have subject themselves to an increased risk of staying out of town, not having transportation, staying in a hotel, and those increased risks with the travel. So I think the policy is that it benefits both the employer in being able to have and assemble quality employees, and it benefits the employee in that if they're injured on one of these trips, that the injury would be compensable. Again, I think that there would still need to be a determination in each case whether there was such a substantial deviation as to cut off that purpose behind that policy and find that a particular injury was not compensable because of some action that took it so far outside of what was contemplated by the employer that it shouldn't be compensable. But generally, Mr. Atkins, again, is staying at a hotel where there isn't any kind of common area for the employees to socialize, and the, you know, he wasn't driving drunk. He wasn't traveling to a different town. He was doing what the employer knew that other employees were doing, walking across the street to a different hotel and walking back when he was injured. Had he been, and the fact of that trip in Oklahoma subjected him to that risk beyond what he would have been subjected to had he had a traditional job where he reported to a factory in Hutchinson and went back home every night.
Thank you, counsel. Any more questions? Thank you both for your arguments this morning and this afternoon. Court will take this matter under advisement. That can